Yes, because I've never been afraid to call myself a feminist. And by feminist, I don't mean a man-hater
No,
at all.
nor
I
do
simply mean that women are the equal of men in dignity and rights.
So welcome to the Speakeasy.
Thank you for having me.
The Speakeasy, its name selected because of a period in history between the wars, where people are sometimes meeting slightly surreptitiously, where politics is not going so well, and also because, we want this to be easy conversation about interesting things with very interesting people. So a huge welcome to Baroness Hale, Brenda Hale, who has just, as well as everything else, published a wonderful book, which I'm now going to brandish shamelessly at the camera, with the law on our side. So this is the second trade book. You've obviously, over the years, written many academic works, but this is, if you like, a follow-up to Spider Woman. But it's a different approach this time, isn't it? It's not memoir this time. It's a wonderful guide to the court system in this country, and to various ways in which the law is there for everyone and different groups of people, vulnerable people in particular. Do you want to say a little bit about the motivation for this project?
The main motivation was the feeling that an awful lot of well-educated, sensible people know almost nothing about the law and the justice system. And if they do think about it, they think it's the criminal justice system. And of course, that's full of sexy stories and can be quite delightful for people to read as entertainment, although it's not very entertaining. But they know very little about the civil justice system, the family justice system, the benefits, public law, all of that. And so the whole idea was to try and get over the importance of it to everybody, that the law can do things for you as well as to you.
And congratulations on it. I think I read it in about 2 sittings.
Oh, well done.
Because it was very accessible, and very engaging. It's in 3 sections, isn't it?
Yeah.
So we have, the first section was really your personal tour of different types of courts and tribunals, from lowly benefits tribunals right up to the Supreme Court, where you finished your judicial career as the president. And you went and spent time sitting at the back of these courts as a visitor and listening and watching and then following up with the outcome of cases that you'd witnessed. What was that like? What was that like to not be the judge, to not be an advocate, certainly not be the judge, and be reporting on a case effectively and not be deciding it?
That was good fun. I went along to these various courts and tribunals on a random day. It wasn't a day picked where anything particularly special was going to happen, but it just meant that I could observe what went on a typical day in these courts and what the judges were doing. I came away with a lot of admiration for the everyday work that the judges do, including the tribunal judges, and a much deeper understanding. I think I'd had it in the olden days. I used to be on the Council on Tribunals, which used to visit tribunals, and so I'd had an admiration for them from then. But it was good to see them still in operation, still, especially the tribunals, but also the county court, still operating in a way which was as user-friendly as it's possible to be for ordinary, everyday people.
But with some pressures.
Oh, lots of pressures. Oh, I don't make any secret of the pressures. The delays in family courts, the fact that there have been court closures so that you have to travel a long way to get to a court unless you're in London. Even in London it can be difficult, but in most other places it's really difficult to get to a local court or tribunal. And the lack of staff and all of the things that make their lives so much more difficult than they ought to be.
And of all of these experiences, in, as I say, I mean, you go to the Royal Courts of Justice, the County Court, Benefits and Employment Tribunals, Family Court, Magistrates Court, Crown Court, and the Old Bailey, as the Central Criminal Court is famously called. Which of these experiences, or which observation in general, surprised you the most?
I think what surprised me the most was probably the York City Magistrates Court, where I went to see a magistrates court doing crime. And I was observing the district judge, before whom all the cases that were supposed to be trials, i.e. not guilty pleas, were listed. And his method was to get the parties in the case, the advocates in the case, in front of him and talk sense into them and get them to agree a way forward which would be beneficial to all concerned and produce a sensible and just result without there actually having to be a trial. He was incredibly effective at doing this.
Goodness. So it was just a particular judicial approach in that.
Yes, I think so. Court. It may be that every district judge sitting in a magistrates court does that, but it was certainly very impressive, very effective. Yes, yeah. I was just a little bit surprised that the defendants weren't there while this was happening, although it was happening in open court, but I was a little bit surprised that they weren't there.
Because they couldn't really give instructions in the moment.
Well, I think they must have consented to, yes, we're going to have a talk to the judge and so on.
Of course. Mm. And what about you being the observer? Because you're not some anonymous journalist or court reporter. How was that? The impact of Spider-Woman herself, of Baroness Hale turning up in the back of my court?
Well, I didn't turn up unannounced,
no.
Except in the Royal Courts of Justice.
Yeah.
I thought I can turn up in the Lord Chief Justice's court when he's hearing criminal appeals.
Sure.
And it's not going to put him off. He'll be all right. In fact, I didn't realise he was going to recognise me. Everybody recognised me. And I can turn up in the media court, and the judge in charge of the media list is going to be okay about that. So, but everywhere else I did write to the lead judge and say, please, can I come and visit you? And they were always very friendly and welcoming. But they didn't behave any differently, I think, from how they would have behaved had I not been there.
And did you notice counsel noticing you, or
well, most of the places there weren't counsel.
Right.
Most of the cases, either people were acting in person or there were solicitors.
And that sort of acting in person element is quite hard for people and for judges, isn't it?
Well, it isn't so hard for tribunal judges,
right?
Because tribunals
were originally set up. Yeah.
They were set up so that people didn't have to have lawyers, because the tribunal would know the law, and the tribunal could run a fair hearing and give each side a fair hearing. And so, mostly in the tribunals, there was at least one side was not represented. In the employment tribunal, where I saw one complicated case more or less the whole way through, the claimant was acting in person and the employer had, I don't know whether it was a barrister or a solicitor, I can't quite remember, but anyway, a lawyer and, of course, part of the team there. So she was up against it, but the tribunal was extremely good in giving her every reassurance and accommodation so that she could make the best case that she did.
Well,
she did very well.
Certainly your respect and admiration for these people who make up the court system, it sort of oozes out of the pages, as well as the clarity with which you explain their work. But they've had systemic cuts in funding for many years now. I think the Justice Department probably had the biggest cuts of any department in the period that we now think of as austerity, though it seems to be often feels like an ongoing period. Was that part of the motivation, do you think, for wanting to explain this work?
I suppose so, at the back of it. I mean, I wanted to try and get over to the general interested public how important the justice system is, how it's not just a nice to have. It's an essential in any civilised society and has been for centuries. We've always had a justice system. We've always had a defence of the realm, and we've always had the justice system. Even before we were a democracy, we had a justice system.
You have the rule of law even before you can aspire to democracy,
long
right?
before it. It's an essential of civilization. To try and get across that people should care about it, and they should care about the fact that the courts are underfunded and not able to do, as well as they could do, the job that we all need them to do.
And I wonder whether you agree with me that in the UK, certainly in England, there's been an element of complacency about rights and freedoms in particular, and perhaps the law in general. I don't know, because people haven't been occupied since 1066 or whatever, and there was this sense that fair play and free speech just sort of come through the tap.
Well, I think we can take things for granted.
Yeah.
We can take a lot of things for granted until they're chipped away at, and then suddenly they're not there. And that applies to the rule of law as much as anything else.
So now going into the second section of the book, this is where you do talk about rights. And you, having addressed the different courts, you now address different groups of ordinary members of the public, but some vulnerable groups in particular. And you talk about their rights. School kids have rights, disabled people, LGBTQ+, workers, women, patients. Do you want to say a little about your thinking in that section?
Well, it was partly to try and get across the fact that the law has to cope with some quite difficult questions. And they come up in stories. I mean, just as my accounts of what went on in the courts and tribunals is a series of stories about what was going on. Similarly, the cases that have to be decided are stories. And so there are stories about children taken out of school for holidays when they shouldn't be, children who don't want to wear the school uniform, children excluded from school. Quite difficult problems. And so what I do is I tell the story, and it's a real case. It's always a real case, usually one I've been involved in deciding, but not invariably. And then I ask the reader, well, what do you think the answer should be?
I know. I actually really loved that, and I can see that being particularly helpful and accessible to people to make them think about these, these potential clashes of rights. That's or just difficult problems that need to be solved. And what would you do? What did you think about the importance?
And things are not that straightforward, are they? What about the man in the wheelchair and the woman with a sleeping baby in a buggy, that sort of thing?
Trying to get on the same bus and there's only space for one. I thought that those examples were really helpful, and I hope that people will stick with the book and get into that section, perhaps in particular, perhaps most of all. Yeah,
well, that's the substantive one, to try and, again, get over what the law is trying to do, which is find a right, sensible, just solution to some really quite tricky issues.
Absolutely. One of the groups, of course, is women. It's Chapter 13, Women Have Rights. Now, you have been an unashamed champion of women's equality in general, but women's equal representation and advancement in the legal profession, in the judiciary, and sometimes taken a bit of flack for that in some of the press.
Oh, yes.
Not just in the press, sometimes from some of your brother judges.
Well, yes, because I've never been afraid to call myself a feminist. And by feminist, I don't mean a man-hater.
No.
At all.
No,
I simply mean that women are the equal of men in dignity and rights, and women lead different lives from men, not necessarily from choice, but from the way they are reacted to by other people. And so, just as a black person will say, I lead a black person's life, not necessarily because of a choice, but because of the way other people treat that person and react to that person. Well, similarly, women's experiences are different from men's, and they should be as much part of shaping the justice system as the experience of white men has shaped the justice system for centuries. That's my feminism.
And that's not, but even that, which seems, of course, totally reasonable to me is not reasonable to everyone. And some of your brother judges at times have warned of the devastating consequences of trying to rush towards equal representation in the judiciary in particular.
Well, I think we've done quite well with a representation in the judiciary this century. And we are now up to over 40% of all the judges are women, which probably represents the number of women in the working age group. So it's obviously not as good the higher up the system you get.
Sure.
But even there, it's over 30%. Forget the Supreme Court, which is a special case for all sorts of reasons. So I don't think we've done too badly with women. There are ways to go. There are things to do. We've got all sorts of ideas about what to do. Ethnic minorities are a much more difficult case, particularly people of black, either African or African Caribbean heritage, where the numbers have remained static for the last decade.
That's very concerning.
And it's only between 1% and 2% of all the judges are of that heritage. And when you think of the representation in the population, in the working population, and in the legal profession, they're grossly underrepresented. So
I think that's a real problem. And when you look at representation in the receiving end of the criminal justice system, in particular, victims and alleged perpetrators, I think it is a real problem if it looks as if one group of people is sitting in judgment over another.
That's absolutely the case. Very interesting comment in a report about this that came out of Manchester University a year or two ago. A magistrate saying, well, there we are. We're taken on all these visits to prisons before as part of our training. Quite a good idea, you might think. And the trouble is, there are so many black people in prison, and it gives you this impression, that black people are criminals, or that they're more likely to be criminals than anybody else. Possibly, it's not a good idea to take us to prisons. I thought that was rather an interesting comment.
To turn the usual assumption on its head about.
Yeah.
There was a row not so long ago, a little while ago now, about the Sentencing Council that I thought in pretty good faith was trying to implement an aspect of the Lamy report and suggest perhaps some more pre-sentence reports when people are from a minority and maybe potentially facing custody for the first time. That turned into, I think, a confected political row about two-tier justice and affirmative action.
Nobody was suggesting, as I understand it, and I don't want to talk too much about the criminal justice system because it's not my special area, but nobody was suggesting that people who were equally blameworthy should not receive equal punishment for their blameworthiness. Nobody was suggesting that. I think what was being suggested is that we need to explore the extent of the blameworthiness in more depth and detail than we currently do.
And the setbacks and the vulnerabilities
that's
and
what I mean
the
about
experience, absolutely.
The quality of the blameworthiness.
And that's really what a pre-sentence report is supposed to help with. I think the nature of the political debate around that was difficult and harsh and perhaps not helping people understand what's going on in the justice system. Now, you have been so many firsts for so many people. I mean, it starts with your starred first-class degree from Cambridge, and then, the youngest, the first woman again and again and again in your career, all the way up to being the first, and for a decade, the only woman in the highest court. Is that quite a big burden to carry, and to carry forever?
Well, of course, I carry it by saying, look, I've been the second woman as often as I've been the first woman, which I think is a very important point to make, because in the olden days, at least, there were some first women who pulled up the drawbridge after them and were very glad to be the first and the only and revelled in that and made it difficult for other women to follow them. Whereas I've been the beneficiary of some very excellent first women who have not done that, and they had welcomed a second woman into Manchester University Law Faculty, second woman into Chambers in Manchester, second woman into the Court of Appeal. All of these I was the beneficiary of the good work done by the first woman. So I've always been conscious of the necessity for a first woman not to pull up the drawbridge, not to frighten the horses too much. And that's always been my problem. Did I frighten the horses? Was that why they found it so difficult to find another woman to join the Supreme Court? I don't think that was the reason. I think there were not many women who wanted to do it. But nevertheless, one always worries about that. That's the burden.
It is a burden, isn't it? But I mean, people really care about what you say even now. You are, if we're looking for analogies, you're the UK's Ruth Bader Ginsburg, for example. So law students, lawyers, people outside the profession actually who are just interested in ideas and in justice. They hang on your every word. That must be a bit of an anxiety at times.
Yes, I'm sure I do say some things that I am not too happy to have said in retrospect, but fortunately they don't tend to get picked up by the media, so that's all right.
But you've also been quite careful without being afraid to at times make comments or explanations when you've seen issues around law and justice distorted.
Yes. Well, I try and make things clear.
So going back a little bit, you were called to the bar in 1968. Is that right? I think that's right.
I think that's right too. It might have been 1969.
Well, let's just say I was born in 1969.
Well, there you are.
So what I'm really trying to get at is perhaps some differences that you have seen along the way from being called to the bar in the late 60s and now being retired as president of the Supreme Court, and now commentating and speaking around the world on the legal profession and on the law. Are there very obvious differences, very stark differences?
Well, the main stark difference was there hardly any women when I was starting out. Whereas by the time you were starting out, which obviously would be 18 years after 1969, things had changed quite a lot.
Yeah.
I mean, when I went to Cambridge, there were 3 women's colleges and 21 men's colleges, so there weren't a lot of women about. There were no women on the law faculty staff. Not for another 20 years after I graduated was there a woman on the actual law faculty staff. It was better when I went to Manchester. As I say, I was the second permanent full-time woman member of staff, and there were many more women students. And of course what I observed in the 18 years that I was teaching in Manchester from 66 to 84 was the steady growth of the number of women reading law. I think they got up to at least a third of the law faculty by the time I left. And you will have been part of that movement, you see. So things did change. That was the major change. The other thing, of course, was that when I started out in the law, on the whole, there was a huge amount of optimism about access to justice. And there's a bit of a tendency to equate access to justice with access to lawyers. And of course, there's an overlap, but it's not a complete correspondence. And the scope of the legal aid scheme was developing all the time. It's covering more and more things. It was still paying enough for lawyers to make a reasonable, not a good living, but a reasonable living out of it. And its coverage eligibility still covered a lot of people. And that was going up, which is why quite a lot of people made quite good careers as barristers and solicitors, advocates in litigation or whatever during the 70s and the 80s. And then it started to be cut back bit by bit.
So you've watched advancement in, say, women's representation and decline in legal aid.
Yes.
And an aspect of access to justice.
Yes, definitely.
I think that's tragic, and I think that will go inevitably hand in hand with this lack of understanding of the legal system and even disillusionment with it.
Yes.
Because if if the taxi driver and the hairdresser, if they cannot get help when they need it, but they read the newspapers and justice is all about criminals, refugees, non-nationals of various kinds, but it's never about me.
Yeah.
And, my difficult relationship with an employer or local or central government or, a global corporation that has sold me some rubbish, I can become very disillusioned with the law.
That's a reason for writing the book. But talking of hairdressers, I was very impressed when I was having my hair washed at my hairdresser's a few weeks ago, and the young woman who was washing my hair said that somebody had ripped her off, sold her something that wasn't what she'd wanted, and she asked for her money back, and she was going to take them to the small claims court if she didn't get her money back. And I later learned she did get her money back. So this is a good example.
So do you think had she been doing your hair for some years and been inspired by your example?
I have no idea. No, she hadn't. I think it was just a lovely example of somebody who did think that the justice system could work for her.
And we just need more. I think we need a bit more of that.
We need more of that.
And it's not even about going to the small claims court or to any court. It's about just knowing what's right and being able to just make the argument even with the shop, with the employer, with the landlord. These really important relationships in people's daily lives. So going back to the book, the final section is about making law, and I think this is very important too, because this is really about how very important decisions about what's right and wrong are made in our society, and you talk in 3 chapters about making law in the courts, making law in government, and making law in Parliament. And of course, you have been involved in 2 of these elements of the Constitution. But do you want to say a little more about the observations in the book on making law?
Well, I thought it was quite important to get across the fact that there are 3 lawmaking methods in this country, and that quite a lot of law is still made in the courts. Not the law that most people are going to encounter, perhaps, but no, quite a lot of it. And so I picked on 3 Supreme Court cases with difficult questions of law and gave an account of how the Supreme Court had decided this. One of them was the one about the Tate Modern.
Yes.
With their new viewing gallery, which enabled people in the viewing gallery to look into the flats of people in very expensive flats built next door. They wouldn't have been able to look into these flats had the flats not had plate glass walls. If they'd just had ordinary windows, it would have been all right. But of course, the whole point of the flats was to have these plate glass walls. And so the question was the Tate's right to use its building and its land as it wanted to do, how did that fit in with the flat owners' rights to use their flats, their building? And it all boiled down to what was a natural and ordinary use of the land. And by a majority, the Supreme Court decided that the flat owners' use of their land was ordinary, whereas the Tate Modern's use of its gallery was not ordinary.
Yeah, I mean, some of these things are really quite difficult.
Oh, it was incredibly difficult. I mean, it had reached different conclusions on the way up, and it was a 3-2 decision in the Supreme Court. But that was just one example. I just thought it was rather a jolly one in a way.
It is a jolly one, and something that can really get people engaged.
Yeah.
And again, what would you do? What would you decide?
That's
that
right.
kind of element is in your description.
Yeah.
However, that notwithstanding, you will always be remembered, at least in part, for the prorogation case, which was, I won't say it was your last hurrah, because you have many hurrahs to come, but that was hugely significant, wasn't it? back in
Yes.
back in 2019.
It was hugely significant. It was not significant for the reasons that a lot of people thought it was significant, because people tended to think that we were deciding whether Brexit should happen.
Not at all.
And we were never deciding that. That had been decided. We were deciding what was the correct constitutional way of bringing it about. And shutting down Parliament
Exactly.
for 5 weeks at a critical moment did not seem to us to be constitutional. There was basically no reason to do it, or at least we had not been supplied with a good reason to do it. And so the whole of the Supreme Court, all 11 justices, said that this was outside the possible bounds of the use of the power to shut down Parliament, well, suspend Parliament.
And that was in your presidency, towards the end of your presidency. Goodness me. I mean, if one were writing a movie, one would have that as one of your final cases as the president of the court. One of the many reasons why I think that case was so important is that more generally, before that moment and since, some people in political discourse present this constant tension between Parliament and the courts. And I think sometimes this is a sleight of hand, because they really mean the executive and the courts.
Yes.
Not Parliament, but the executive, the government of the day.
This is true. And this is what we always have to say. In both of the very well-known cases that we had about Brexit, it was all about the powers of Parliament.
Yeah.
In opposition to the powers of the government.
But in the second one in particular, in Miller 2, the prorogation case, it's just so graphically there that the executive has shut down Parliament.
Yes, that's right.
Now, that could almost be a metaphor for so many other important constitutional cases where the courts as referees are actually trying to empower Parliament, are actually trying to interpret the statutes that Parliament has at least notionally created in the face of an interpretation and application by an executive that doesn't always and hasn't always respected Parliament and parliamentary sovereignty that much.
Well, that's one of the points that I hope emerges from the second of the lawmaking chapters, which is a chapter about lawmaking in government, because the government does make a lot of laws. It makes a lot of what we call delegated secondary legislation, because they've been given by Parliament the power to do that. And then the question for the courts is what is the rule that they have made within the powers that Parliament has given them to make these rules. So a power to set fees for tribunal cases, did Parliament intend that could be used so as basically to make it prohibitively expensive to go to an employment tribunal, which is what that case was about.
Yeah.
So again, we're standing up for Parliament against the executive, which is overusing the powers that Parliament has given.
Oh, absolutely, and I think you make that point so well with the explanation of delegated legislation, which again I think a lot of even highly educated people, teachers, journalists, even some politicians at the beginning of their careers will not necessarily understand. So I certainly recommend the book for all of them, for anyone who's just kind of politically interested, let alone legally interested. And then the final section, the final chapter, is obviously making law in Parliament. I think I even get a mention in there somewhere.
You do indeed.
That was a bit of a
yes.
that was a bit of a surprise. But I think it was perhaps the Rwanda case where
Well, what I do in that section, apart from explaining legislation, is give an extended account of the passage of the Safety of Rwanda bill, because I thought it was a very good illustration of the importance of the argument and of the way in which legislation gets through both houses of Parliament. And it was particularly interesting in the Lords, where the Lords did a very good job in
holding government to account.
Holding the government to account, and attempting to introduce something sensible into this otherwise constitutionally pretty objectionable piece of legislation.
And again, trying to respect the Supreme Court's
Yes.
decision that, in fact, in truth, on the evidence at that time,
Yeah.
Rwanda was not safe.
That's right.
In the face of a statute, an edict almost, that regardless of those factors found in our highest court, Rwanda will be deemed safe, not just for today, but forevermore.
Forever, yes, until we repeal the Act, yes.
And I agree with you. I had the privilege of listening to some wonderful speeches in those debates from some of your crossbench, well, from you, of course, but some of your crossbench colleagues, the great Peter Hennessy, for one. And actually, some of the finest speeches were from Conservative Privy Councillors, because the rule of law need not be a party political matter.
Well, it isn't a party political matter. I mean, everybody will say that they believe in the rule of law. They do tend to confuse it with law and order. And, of course, it's something very different because it is, in effect, that society is governed by rules and everybody is subject to those rules. Not only the people, not only the governed, but the governors and the rulers. Everybody is subject to it. And that goes back to Magna Carta.
Yeah.
Not 1215 Magna Carta.
Yeah.
Actually, one of the most exciting things that I did the other day was open Durham Cathedral's exhibition called Magna Carta and the North. And Durham Cathedral possesses the only copy of the Magna Carta of 1216.
Remind me about Magna Carta of 1216.
Well, you know, King John sealed Magna Carta in 1215.
Yeah.
Within weeks, he repudiated it.
Of course he did.
Because the Pope basically told him to, persuaded him to. So, and then he died, having lost most of his baggage in the wash. Not the laundry, but the wash. And his 8-year-old son took over, Henry III, and William Marshall basically was in charge. And he persuaded the king, the boy king, to issue Magna Carta in 1216, basically to placate the barons so that they would still say, yes, we've got the bits in the Carta that we like, but they cut out the bits that had so enraged the Pope.
Right.
And this was the foundation of all the subsequent versions of the Charter that were issued throughout the 13th century. So it's a really important document. So I was thrilled
to be able to
put one's eyes on it.
So it is fun. So with these burdens and responsibilities also comes some enormous fun.
Oh gosh, yes.
And you are enormous fun. There's no doubt about it. You've had to deal with some very serious matters, serious in people's lives, right back from your practice and from your law commission days, when you were so influential as a law commissioner in developing things like the Children Act, so important in people's lives, but also for our constitution. But you also enjoy the work and have fun that isn't even work, right? Yeah. You love music and theatre, and there's so much more to you perhaps than just the law, though the law is plenty.
Though the law is fun as well, isn't it?
It is.
I think that's another thing to try and get across to people, that of course it's very serious, of course it matters, but actually it can be so engaging.
Well, people find it engaging in their crime procedurals, for example.
They do.
And we have a mutual friend who's a huge enthusiast and an expert. But yeah, there is a lot to stimulate and educate and be inspired by, essential to civilization. Look, because you mentioned Durham, I want to explore a part of your identity we haven't spoken about, but it's so important. We've done the lawyer and the judge and the woman, but the northerner. I think this is actually a very important part of your personality and your identity and your history. Am I exaggerating that?
No, I don't think you are. I was born in Yorkshire. I grew up in Yorkshire. I went to school in Yorkshire. Obviously, I left to go to university and go to work. This what tends to happen if you come from a rural environment. You're going to go away for a career. But I have a home in Yorkshire. I feel very strongly aligned with Yorkshire and some of its values.
Go on about its values.
Well, I know Yorkshire people are accused of being mean.
That's a terrible stereotype.
Yes,
yeah.
It's a terrible stereotype, but they are actually quite careful. So if something goes wrong in your house and you get a tradesperson to come and look at it, their first reaction is going to be, how do we repair it? Not, oh dear, that's kaput, let me sell you another one. So there's that about it, which is very principled and satisfactory. People are friendly.
Yeah, I think so.
People are friendly. They talk to one another in the street, in shops, in whatever. I think that's good. People look out for one another. I mean, during COVID, an awful lot of looking out for people went on in my town, which was great. So there are those things. There's probably a sort of principle there. I think possibly about fairness. Not so sure about that, but I think so.
And certainly community.
Definitely community, yeah.
And warmth and hospitality and all of those things. And, of course, it's a beautiful part of the country.
I'm going to say it is a lovely part of the country, yes. It's a great privilege to live there. I mean, I grew up thinking that everybody got, an ancient medieval town with a ruined castle and a ruined abbey and a cobbled marketplace and beautiful scenery. I thought that was standard.
And then you went to Manchester.
Then I went to Manchester, yes.
Which is wonderful in its own way.
Manchester is wonderful in its
own way. But that's crossing the Pennines, isn't it? Isn't that rather serious?
Yes and no.
Okay.
It's a bit like...
How did you get over that?
Well, I was offered a job in Manchester when I left Cambridge, and I was offered jobs in Bristol and in Manchester, and I chose Manchester. And a lot of people would say, 1966, you were choosing Manchester over Bristol. Who in their right mind would do that? The reason that I went to Manchester is that they wanted me to qualify as a barrister and practice as a barrister at the same time as being a university teacher, which you could do in those days.
And how lucky we all are that you did that.
Well, how lucky I was that I did that. It was the best decision of my life, there's no doubt about that, to go to Manchester rather than to go to Bristol.
And to combine
yes.
an understanding of practice in the courts with the academic study, both of those things being so important for your subsequent work
yes.
at the Law Commission and, of course, in the higher courts.
No, that's true. So it was the best decision of my life.
And
despite its being Lancashire rather than Yorkshire.
There've been other good decisions in your personal life and
yes.
your judicial life, of course. Perhaps just some final thoughts on the relationship between the law and politics, between the judges and the politicians in difficult times. And I fear that we are in difficult times. I think we've been in difficult times for some years, actually. Maybe since the dawn of the 21st century. For people who think this is a permanent and fierce contest for power and dominance, what would you say to them about this mutuality of respect that some of us think should be there, or just the relationship between politicians and judges?
Well, I think there should be respect. I think respect has to be earned and deserved. So we all have to understand what our different roles in the process is. That's one of the reasons for trying to explain the different roles played by parliamentarians, politicians who are in government, and the courts are in making the rules and in applying the rules. And we all have our different functions. Yes, the courts do from time to time make law, but most of what the courts do is apply the laws that other people have made. And they are not seeking power and domination, not at all. Certainly not over the democratically elected parliamentarians. But we are seeking to get the rules properly observed.
And what about the relationship between our laws made by these different elements of the British Constitution, of the UK Constitution, and international law? Because this has become a particularly contentious area of political discourse, hasn't it?
Well, it has. And of course, most of international law is derived from treaties. Treaties are contracts between the member states. And as in any contractual situation, you give up something in order to get the benefits of what other people have promised to do for you. So international trade would not work without the rules about carriage of goods by sea, carriage of goods by air, carriage of people by air, carriage of goods on land. There are treaties about that which apply uniform rules that help everybody, help the wheels of commerce keep going. And that's true of most international treaties. You give up something so that you get something in return. And that's why international law is so very, very important. Now, of course, it goes on to bigger issues like that, like international humanitarian law, which was developed after the Second World War, so as to try and prevent some of the worst things that had happened during the Second World War. And again, people may think it's never going to apply to us, but then things happen and maybe it does apply to you, or it might come rather closer than you thought. And so it's very, very important that people should respect the internationally agreed rules of civilised behaviour.
And surely the world of the 21st century is shrinking and more interconnected than ever, with challenges like climate change and the internet and so on. And how bizarre if we have globalisation for trade and terrorism, but not internationalism for example, human rights.
Yes.
That would be very lopsided, wouldn't it?
Well, it would be very lopsided. And I think international law does get broken from time to time.
Yeah.
And sometimes it gets broken in circumstances where most people would say, yeah, that was the right thing to do in the circumstances, or at least understandable. Whereas we can hardly ever say that in relation to national law. So I'm not giving international law quite the same status that national law has. But I nevertheless think it's incredibly important that we continue to have a rules-based international order to make the world go round, to make the world a more civilised place. We all benefit from that.
And you, since retiring from the judiciary, you have at times quite carefully and judiciously signed with other jurists and practitioners letters and statements about burning topics of international humanitarian law and international law, like the conflict in Gaza. Do you think that that's an appropriate thing to do? Do you think that is, now that you're retired, do you feel that that making comment about international law is easier for you?
I don't do it very often.
No.
I did sign a letter to the government about the supply of arms to Israel because of the use to which they were being put in Gaza. And that was because I was satisfied, on the basis of having read the opinions of international lawyers whom I respected, and also the opinion of the International Court of Justice, that it was the right thing to do. And similarly, of course, I have spoken up in favour of the European Convention on Human Rights.
Well, indeed. I mean, I was going to sort of come to that climax, really, because I suppose I've just recently had the privilege of joining the UK delegation to the Parliamentary Assembly of the Council of Europe, and I notice, well, you can't help but notice that it isn't just right sceptics in the UK that now want to change or even renege upon the convention, repudiate it. There are voices elsewhere in the Council of Europe too, and of course we've seen Russia be expelled because of its illegal war with Ukraine. What do you think we would lose, not just as a United Kingdom, but as a continent of Europe, if the convention were to be dismantled?
Well, I think it would be a disaster for Europe. I don't think that'll happen, frankly. I think there is scepticism, but I don't think it'll be dismantled. But I think it's one of the greatest achievements of European civilization since the Second World War. Some of the constitutions in continental Europe also are great achievements, but the convention put into language, quite simple language, the rights which everybody ought to have. Now, there are criticisms about the way in which it's been interpreted and expanded, and we could go on forever about that, and I don't think. But the actual underlying concept that there are certain basic rights which every human being should have by virtue of being human is absolutely crucial. And that's why it was so objectionable, among several other things, in the Rwanda bill, that it excluded a whole class of human beings from access to those basic rights. Now that's wrong. In so many ways it is wrong. You can restrict the rights. It will be open to our Parliament to say all foreign national criminals can be deported, and all you can argue about is whether you are a foreign national criminal. You've got to be able to argue about that. But you can't argue about the rights and wrongs of your deportation. It'd be open to Parliament to say that. And I'd rather they said that than they excluded the people from access to the courts altogether. I don't want them to say it, but I would rather that they said that. I'd certainly rather that they said that than they withdrew from the whole thing.
Of course. Yeah. But that's a sort of very defensive position, isn't it? But and it is the nature of some of the domestic discussion. Yeah. We won't pull out altogether. I mean, some people in politics want to pull out altogether. Yeah. And I think that is definitely going to be on the agenda at the next general election. Some parties will advocate pulling out of the convention altogether. Some of them, I think, suggest it's Brexit too, that you're not properly Brexited if you haven't come out of the Council of Europe. But others, as a sort of defensive position, it's not a world away from David Cameron's previous approach to the EU, which was he was going to go to Brussels and get various concessions and compromises, and then we would stay in. I think this is, even some people in my party want to, for example, reform Article 8 in the context of migration. So say we go to the scenario you describe, all foreign national criminals, quote unquote, will be deported, full stop.
Or can be deported.
Deported.
Yes, I don't think it will be, because deporting people is easier said than done.
Easier said than done, as so many prime ministers, one after the other, will find in the practicalities of negotiation.
All I am saying is that staying in the convention and keeping to the principles of the convention is incredibly important. If there are things about it that are causing all of this, it's better to try and see what sensibly and proportionately can be done to address that problem.
But you can address real problems, but you can't address xenophobic appetites that are not universalist, because human rights are, as you articulate, for all humans, regardless of nationality, which we're finding all the time can be given and taken away. I believe that the US president is now talking about deporting people who are American citizens, some of whom aren't even naturalised, some of whom were born in the US. The comedian Rosie O'Donnell, I think, is being threatened with deportation on social media by the president. So at the end of the day, and people can be deprived of their citizenship. So it's a very big step, isn't it, to say we don't believe in universal human rights because we're all foreigners in most places on earth. But to go back to your point, if, for example, for argument's sake, a government of whatever stripe or stripes if it were a coalition, said we're going to legislate that all foreign nationals convicted of a criminal offence can be deported. That would mean that a person, an adult, who had come to the UK as a young child, perhaps, as a very young child, and lived all their life.
Might even have been born here.
Because
we don't have birthright nationality any longer.
Indeed. No links to another country, no other language, no family, etc., etc. They're going to be deported for a crime that may not even be the gravest of crimes. That is going to bump up against Article 8, even a tweaked Article 8, isn't it?
Well, of course it is. And the scenario which you describe would, of course, be wrong. I think the only point I am trying to make is that it is better to address real problems in a real way, in a sensible way, than to condemn the whole enterprise, which is what is being done. Which is why I am focusing on saying, well, look, if you think there's a problem there, identify the problem and identify a sensible way of dealing with it. Don't condemn the whole enterprise.
And you take the same position on the Refugee Convention, which is at the moment the other big post-war legacy that is under attack for being outmoded, outdated. I mean, I hear so often in our chamber in the House of Lords, people say, well, of course we want to protect people. Look at what we've done for Ukrainians, for Hong Kongers. Of course we want to protect people. But the Refugee Convention is very outdated. And, the 1940s are very different from the 2020s.
Well, the interesting question, of course, is why did everybody agree to the protocol in 1966? Because
only a couple of years before you were called to the bar.
Well, a lot of things happened in 1966 in terms of human rights. But obviously the Refugee Convention, when it was first devised, was dealing with the refugee problem in Europe at the end of the war. And it was time limited and it was geographically limited. And then they extended it. They extended it worldwide. They extended no time limit. And so we now have a situation which probably was not foreseen, certainly wasn't foreseen in 1949, and probably wasn't foreseen in 1966, that large numbers of people are on the move for a variety of reasons. Large numbers of people are refugees in the colloquial sense of being a refugee, because the Refugee Convention was all about persecution.
Not about climate emergency.
It was not about civil war.
Yeah.
It was not about climate change. It was not about extreme poverty or anything. It wasn't about any of those things. It was all about persecution. And so it doesn't quite fit, actually.
Some of the
situations which people would be extremely sympathetic to. Ukraine, for example. People extremely sympathetic to Ukrainians, most of whom would not qualify under the Refugee Convention.
No.
Because they're not being persecuted. They're fleeing war. And this is true of quite a lot of people. So I think that issue is incredibly complicated. And if the world could get together to rewrite the convention in a way which better suited the modern world, well, that would be a great thing. But we don't want to get rid of the only thing we do have at the moment to try and protect some of the most vulnerable people in the world.
So for the meantime, we stick, not twist, because the twist would probably lead to a dilution of rights.
In the meantime, yes.
Yeah. Do you think it's important that when you were the young law student and the young lawyer, memories of World War II were fresher?
Probably. Yes, probably. Well, when I was a child, I was born right at the end of the World War II, but there were memories of the war all around. There was an airfield, a wartime airfield in the village. There were people who were living in Nissen huts in the village, having been bombed out of their homes in Teesside. there was a big army camp just down the road. So we were very well aware of war and of the devastation that war can cause. And so very sympathetic to all the things that were done in the immediate aftermath of the war to try and mitigate some of the harms. Not all of them, obviously, can't be done. But yes, I expect, though on the other side of that, when I was learning international law in Cambridge, 1963-64, I do not remember any reference to international human rights, or there might have been some reference to international humanitarian law, because we did do the law of war.
The law of war, yeah.
But not... that's partly because the Universal Declaration had not yet been translated into binding instruments. That happened in 1966.
Exactly.
Which is why that was such an important time. So I wasn't...
It's not just about football.
It's not just about football.
Brenda, what can I say? You're called the Spider Woman because of a brooch that you happened to wear at work one day. And maybe this is the problem with being an icon. Everyone's looking at everything you're wearing. It's not just women, to be fair, because I think the king's ties are examined very carefully for what colours they include when he's meeting with dignitaries. But you're called the Spider Woman because of that case and because of that brooch. But actually, it's rather apt because it's a superhero's name, and I think to so many of us, you have been such an inspiration. Perhaps a very self-deprecating superhero, but a great fighter for right and justice. Nonetheless, thank you so much for the book. Look forward to the next one, and thank you for sharing your time in the Speakeasy today.
In the Speakeasy, but we're not there to drink illicit alcohol, which is what speakeasies were all about.
Yeah, but who knows what's really in the mug? People will have to judge,
They were okay. Leave them hanging.
Leave them hanging. Brenda, thank you so much.
Thank you, Shami. Thank you.